International laws governing shipbreaking. Shipbreaking is by necessity an international industry. Several international laws have relevance to shipbreaking matters. Among them, the United Nations Convention on the Law of the Sea 1982 or UNCLOS, the Nairobi International Convention, the Anti-Fouling Convention or AFC 2001, the Ballast Water Management Convention or PWM Convention, and MARPOL are mentionable. However, none of them has been found to address the issues directly and in a comprehensive manner. The only enforceable international convention that materially affects the EOL ship is the Basal Convention on the Control of Transboundary Movement of Hazardous Waste and Their Disposal, in short, the Basel Convention. The Basel Convention was adopted in 1992 to resist the temptation by the developed nation of the practice of exporting hazardous waste into undeveloped nation territories simply for money in the name of recycling. This convention restricts any cross-border movement of hazardous waste either by rail, road, or in seaways. An EOL ship is deemed to be hazardous waste in international law and is subject to this convention. However, the convention only attracts the movement of EOL ship last journey toward the recycling facility and is not associated directly with the mainstream ship recycling activities. Enormous controversy exists within the dominant stakeholders about its applicability to EOL ship. Nevertheless, in the face of a legal vacuum to manage the threat against safety and environment from shipbreaking, this instrument has consistently been used as a mighty weapon by the ENGO. ENGOs have used this law to file cases in their domestic court preventing journeys of EOL ships toward those recycling states that have no or insufficient capacity to recycle ships in a safe and environmentally sound manner. Importantly, the convention shore-based gateway system of control sits quiet inappropriately on the typical mobile waste that is an EOL ship flying across the ocean. Under this convention, a ship can turn into hazardous waste at any moment, even on the high seas, as soon as its owner decides to recycle it, and at the time when the flag state jurisdiction over the ship at sea is entirely unknown to this convention. The Hong Kong Convention, the International Convention for the Safe and Environmentally Sound Recycling of Ships, referred to as the Hong Kong Convention or the HKC, is a specialized treaty adopted by the International Maritime Organization or IMO in 2009 to regulate the global shipbreaking industry, but the convention isn't yet enforced due to the problem of ratification. Significant controversy exists with regard to this convention on the allocation of burden in the cooperative venture of shipbreaking between important shareholders. Notably, considerable burden have been imposed on the ship recyclers under the convention, including pre-cleaning of ships in their own territories. With some exception, almost all the ship recycling facilities in South Asia that cover almost 80% of tonnage recycling capacity worldwide suffer from a lack of infrastructure to carry out this work in a safe and environmentally sound manner. The convention hasn't reserved any provision for funding to develop infrastructure and capacity for the recyclers who risk their workers' health and environment by employing such hazardous activities in their domestic territories. It has failed to address the practical issues like liability of polluters. Instead of holding the beneficial owners of ships accountable, the convention has assumed that the ship recyclers are the real polluters with associated liability of mitigating pollution exclusively at their own expense. The HKZ ignores that ship owners sell their obsolete vessel at the standard market price for scrap steel without any adjustment to take into account the cost of disposal of hazardous waste and the environmental degradation of the recycling state. Ship owners are left with no burden except preparing a document called Inventory of Hazardous Materials or IHM, which carries the list of hazardous material available on board throughout a ship's life. However, the convention has failed to show any benefit this simple piece of document will bring to the impoverished recyclers who have no or minimum infrastructure and use no advanced technology or equipment. Most of their workers cannot even read the document and are unable to execute the sophisticated works required to follow the information on the paper. To offset this lopsided distribution of burden, the HKC has left the recycling state with absolute discretion in setting their own standard of safety and environmental protection, including setting the minimum standard for equipment and technique used in shipbreaking. The HKC doesn't accept any responsibility for downstream waste produced from recycling of ship recycling facility. Breaking the tradition of other IMO conventions, the HKC has ignored all the well-established principles of environmental laws such as the polluter pays principle, the principle of intergenerational equity, the proximity principle, the principle of prevention, common but differentiated responsibilities, and the precautionary principle. This was precisely the scenario existing in South Asian shipbreaking since the 1980s, when these recycling facilities used to operate based predominantly on manual force with a subsistent level of equipment and technology. Arguably, the convention has retained this bare minimum standard and given this parochial tradition an unofficial status. Many of the existing malpractices, such as ship owner bypassing responsibility by creating camouflage intermediaries, the cash buyers, have officially been endorsed by the HKZ. Ship recyclers' use of slime ball contractors and the cash buyers' use of unscrupulous flag state have all been implicitly ratified by the HKZ, thereby giving all these malpractices formal recognition. All of these significant loopholes in fact created the agitation for a new global regime on ship recycling after 3 decades of mobocracy and lawlessness in global shipbreaking. Because of the lowest standard for safety and environmental standard in shipbreaking offered by the HKC, it may be almost impossible to avoid a race to the bottom among the cash-strapped recycling state. In this connection, the command of the Goldman Environmental Award winner 2009 and Greenpeace representative advocate Sheda Rizwana Hassan, the Hong Kong Convention is noteworthy. When the workers and the environment of developing countries desperately needed a life ring, the IMO threw them a useless paper. The Hong Kong Convention and the South Asian response to control the domestic ship recycling activity, Bangladesh adopted a dedicated framework of regulation on ship recycling, namely the Shipbreaking and Recycling Rule 2011 and the Hazardous Waste and Shipbreaking Hazardous Rule 2011 and the Ship Recycling Act 2018, taking note of the HKZ. The 2018 Act of Bangladesh has mostly dealt with allocation of plots between recyclers and constitution of the Shipbreaking Board or SBB, which is the competent authority for regulating the shipbreaking activities in Bangladesh. 9 years have elapsed since 2011, but these measures do not seem to have made any material impact either on the growth of business in Bangladesh or on the rate of casualties. Thank you.